background, some of the legal concepts, but also the kind of the context of the nation of Puerto Rico and what is it that brings us to the point where we have the third case before the Supreme Court in 3 years around Puerto Rico. The first two from 2016 that you all may be familiar with, both looking at really the political relationship between the United States and Puerto Rico, and the other around the economic crisis, the fiscal crisis, that both of them kind of evolved to lead a couple of weeks later to the federal statute known as PROMESA, which this panel is titled after, that enacted the statutory framework that allowed for a debt restructuring process for the island, that also included the imposition of a federally created control board, the fiscal control board. That is very much part of what this latest case before the Supreme Court was about, and looking at the composition of that control board and how it was appointed and who sits on it. And so there's a lot of interesting legal questions that I want to say too, but also kind of the impact of these decisions that are happening on the island. The last several years, we've seen not only Puerto Rico be mentioned repeatedly in the international and national news because of the economic crisis, but also because of the human rights crisis and humanitarian crisis after Hurricane Maria 2 years ago. Recently, this past summer, the political uprisings that we saw, the popular uprisings that we saw in the street. So there's a lot that's coming to a head, shall we say, on the island. So we'll have each of our guests speak a little bit first about their work, their perspectives, their arguments, the briefs that they submitted, and have a little bit of a conversation here amongst the panelists, and then we'll open it up to the audience for any questions that you all may have. So I'd like to first ask Jessica Mendez to please speak a little bit about. Jessica is counsel for UTIER, which is the union for electrical energy workers, for what we call in English PREPA, the Puerto Rican Electrical Power Authority, and was one of the cases that was granted cert. There was several cases that were granted cert that were combined, and she participated in an oral argument, which was 2 weeks ago, I think now, 3 weeks ago now.
It's been a month, maybe, October 15.
It's been a month already, a month now. So part of the idea also right before I pass on to Jessica, and us having this conversation is obviously a little bit of, I'm not a football fan, but like the Monday night quarterbacking, anticipation, looking back and anticipation before we get the decision to look at what, what the impact and consequences of that kind of decision. So Jessica, you want to start us off?
Thank you, Natasha, and thank you everybody for coming and for inviting us. For us, it's very, very important to be able to speak about this case and explain what it is about, because it is something, PROMESA and the Oversight Board is something that is affecting the people of Puerto Rico every day, but still it is, to this day, it has been seen as the financial crisis and the bondholders, and there's not that much attention to the labor unions that are being affected by the decisions of the Oversight Board and the people as a whole. So as Natasha mentioned, we're from, my partner and I, we are from a very small firm in Ponce, Puerto Rico. Excuse me. And we represent this labor union that it is the biggest labor union of the Puerto Rico Electric Power Authority. And the case started in 2017. PROMESA was enacted in 2016 and imposed the Oversight Board with such an amount of powers and authority that even though PROMESA says that the Oversight Board is an entity within the territory of Puerto Rico, it cannot be said that they are actual territorial officers, because when you look at the essence of all the powers that the Oversight Board has over the government of Puerto Rico, it can be concluded that they are in fact federal officers. When we apply the test of the Buckley cases and the Lucia case, which was a recent case in 2018 about the appointments clause, we see that they are, in fact, exercising federal significant authority. Now, what's the problem with that? PROMESA establishes a form of appointment of the oversight board members. They are 7 members, elected members, that, as I mentioned, they are supposed to be territorial officers within the territorial government, but when we look at their responsibilities and their power, they have much more. So PROMESA establishes that they would be appointed through a list mechanism, a list submitted to the president by the members of Congress, and the president would select those 7 members from those lists, but they didn't went through the process of advice and consent of the Senate. The appointments clause establishes that the federal officers should be appointed, have to be appointed by the president with the advice and consent of the Senate because of the significant authority that they have with the respective functions. So we saw that the members of the oversight board have such an amount of power. When I say this, for example, they have the authority to certify the fiscal plan, which is the blueprint for the whole bankruptcy process, and the plan of adjustments of the bankruptcy process has to comply with the certificate, with the fiscal plan. That certification of the fiscal plan is not even subject to judicial review. So if we don't agree with, or we feel that we have been injured by the contents of the fiscal plan and its certification, we cannot question that in court. The fiscal plan is the document that establishes the austerity measures of the board, because PROMESA's objective is to bring Puerto Rico back into the financial markets and at a reasonable interest of reasonable costs. And when we see that the purpose of PROMESA and of the oversight board is for that debt to be paid at the expense of the people. And that's why they come with imposing these austerity measures, like, for example, cuts in the pensions, reducing benefits for the workers, impairing the contractual obligations, the collective bargaining agreements of the workers, which is something that they can do through the bankruptcy process, but they also can impair contracts. The oversight board can impair contracts of the government of Puerto Rico without even being in a bankruptcy proceeding, which is a huge amount of power that it's not even granted to the states, given certain exceptions. So with the certification of the fiscal plan, like I mentioned, the austerity measures, they can also, they have established the plan to reduce campuses for the University of Puerto Rico. We have now 11 campuses, but they are suggesting to reduce it to 3 campuses, which obviously affects the access of public education for the people. They have established to close public schools for children, and a lot of other measures and agreements with the bondholders that prioritize the payment of the debt at the expense of the people without any concern for the well-being of the people. Increasing electricity bills, the rates of the electricity bills, and the payment of that debt ahead from the operations and expenses of the Puerto Rico Electric Power Authority. So they can also approve the budgets of the government of Puerto Rico, and they can do this at their sole discretion. PROMESA establishes a form, a procedure to work that around with the government, but in the end, if the oversight board understands that the budgets or the fiscal plans prepared by the government are not consistent with the objectives of PROMESA, they can impose their own certification of the fiscal plan and the budgets, and that's the one that's going to be deemed approved. They can, I mentioned the impairment of the contracts, they can invalidate laws already approved by the government of Puerto Rico. So therefore, the people in Puerto Rico can vote for the legislature, the governor, but still that vote is useless because every legislation that goes through, every bill has to go through the board first in order for it to be enacted. So when we consider all of the powers that the oversight board has, and that the PROMESA states that the government cannot enact any legislation, any regulation that goes in the opposite direction of the oversight board, or that is contrary to the provisions of PROMESA, we see that they cannot be considered as territorial officers. So we question that through an adversary proceeding in the bankruptcy case of PREPA, which is where we have the standing, and we said that the oversight board's actions were unconstitutional because they were not appointed in accordance with the appointments clause. There was also another proceeding in the Title III, the bankruptcy proceeding of the government, that was brought by Aurelius Investment, which is a hedge fund. They had the same arguments that we have, but they were in the proceedings of the Title III proceedings of the government. We were in PREPA. So both cases were being at the same time. And obviously the government, the government, the U.S. government, and the oversight board and some other parties were they were saying that basically, to put it in simple terms, that Congress enacted PROMESA because of the plenary powers that Congress has pursuant to Article 4, the territorial clause, and therefore they could do basically whatever they wanted with Puerto Rico, and they could enact PROMESA in the way that they did, and it vests the powers that they vested on the oversight board without being restricted by the appointments clause. The judge, Laura Taylor Swain, dismissed the case in the district court because she said that Congress had to be given deference to when Congress says that it is enacting this law according to their power pursuant to Article 4, and that if Congress says that they are territorial officers, then they are. We went to the First Circuit in Boston, and the First Circuit reversed and said that it made an analysis of all the powers that the oversight board has, and it concluded that they are, in fact, federal officers. The problem was that we were left without a remedy because even though the First Circuit concluded that they were federal officers, it applied the de facto officer doctrine and said that the oversight board members were acting in good faith, that there was not any indicia of the faults of the appointments, therefore the de facto officer applied. But the problem was that the First Circuit allowed the board to continue operating even though it concluded that they were federal officers. So we were left with a board that we had a constitutional claim, that we were successful in that constitutional claim, but still there was no consequence, there was no remedy. And let's remember that we are not talking about a mere technicality. We are talking about the appointments clause, which is based on the separation of powers doctrine that ultimately is there to protect the liberty of the citizens and to prevent the tyranny against the people. So we went to the Supreme Court, but with us, the oversight board also, and the United States and other parties also requested the cert, and the Supreme Court granted all the petitions and consolidated the cases. Aurelius also was in the same path as we were. we have to understand that the motivations of Aurelius and UTIER to file and prosecute this case are not the same. UTIER is fighting for the rights of the workers, the collective bargaining agreements that were impaired because of the decisions of the oversight board that we were not allowed to question because the certification of the fiscal plan is not subject to judicial review. Aurelius is just looking to get paid the 100% of the debt. So in the Supreme Court, we had to share our time with Aurelius, so I had only 10 minutes to present my case. And we had two very important issues. Obviously, the remedy. We were asking for the court to invalidate all of the actions of the oversight board because they were unconstitutional and they had no authority to act. Not only those actions after the decision of the First Circuit, but everything. And the other point that we wanted to raise to the court was the issue of the insert cases. Since the beginning of the proceedings, the other parties, the oversight, especially the oversight board in the United States, were relying on the insert cases to state that even the structural provisions of the Constitution, like the Appointments Clause, didn't apply to Puerto Rico because it is an unincorporated territory. For those of you that are not familiarized with the insert cases, those are cases that were decided at the beginning of 1901 when the United States acquired Puerto Rico and other territories at the end of the Spanish-American War. And there, the court was faced with what are we going to do with these territories and if the Constitution applies in its whole extent to these territories or not. And as a result of those cases, it was decided that Puerto Rico belonged to the United States, but it was not part of the United States. And there was the court created the incorporation doctrine, which stated that those territories that were incorporated, that were in the path to statehood, were entitled for the applicability of all the provisions of the Constitution, and those that were unincorporated territories were not in the path to statehood. Therefore, only those fundamental rights of the Constitution would apply, but the whole Constitution would not apply. We're talking about the Exports Clause and other things related to tariffs, but also in those cases, the court said that even the jury trial would not apply to the unincorporated territories. And the reasoning of the court in all of these cases was a racially motivated reasoning to say that these people that are different in race, different in customs, different in legal systems, in religions, were not capable of understanding the Anglo-Saxon principles of the Constitution. Therefore, the Constitution could not apply to them in its whole extent. So obviously they are racist cases that have been good law since 118 years, since they were decided. And from the beginning, the other parties have been relying on the insert cases to say, well, the Appointments Clause is not a fundamental right. That is based on the doctrine of the insert cases. Therefore, the Appointments Clause doesn't apply. Congress was acting pursuant to its powers under the Article 4 of the Constitution, the Territorial Clause. Therefore, Congress could do whatever, basically whatever it wanted with Puerto Rico as an unincorporated territory. And when we went to the First Circuit, we obviously have been arguing throughout the case that the insert cases should be overruled because they are not good law. They are a court-made territorial doctrine. It's territorial doctrine that's made by the court with no basis on the text of the Constitution itself. And when we were at the First Circuit, we argued about the overruling the insert cases, but obviously the court, Judge Torruella, told us, well, we don't have the authority to overrule the insert cases, and obviously we knew that, but we wanted to make clear to state that the court could not overextend the reasoning of the insert cases to this case, because we were not even talking about those fundamental rights that the insert cases were about. So the court did just that. The court said, the First Circuit said that they were not going to extend the insert cases beyond their reasoning, citing the Reed versus Colbert case where the Supreme Court said that about the insert cases. But when we were at the Supreme Court, we took that opportunity to say to the court, which was never done before in an oral argument, to say the insert cases are racist and the insert cases should be overruled. And so my argument was based on those 2 points, because Aurelius was arguing the same thing about the significant authority of the oversight board, and they were also questioning the remedy issue. So I understood that they would be able to, that they would have more time to focus on that. So we addressed the issue of the insert cases. Obviously, the court was very resistant to that topic, and Chief Justice Roberts asked me if why would they even look at the insert cases if the parties were not relying on them. That wasn't correct, because at that point in the Supreme Court, the Committee of the Unsecured Creditors, which was a part at the proceedings but was not arguing before the court that day, they were relying on the insert cases at the Supreme Court stage. The Oversight Board was not mentioning them at all, and the United States was basically saying that they were not relevant at this stage. I told the Chief Justice, that it is very convenient for the parties to rely on insular cases throughout all the proceedings before the lower courts that don't have the authority to overrule them. But when we get to the Supreme Court, they simply abandon that argument. And with respect to the question that the Chief Justice made about the insert cases not being relevant, and that it would be unusual for the court to address them even though they are not relevant, I just gave the Chief Justice the example of the Korematsu versus Hawaii case, and the Korematsu versus US case, that last term in the Trump versus Hawaii case, the court, the opinion written by the Chief Justice, he said the Korematsu case has anything to do with this case, but still it is morally repugnant, and the court overruled that case. So I gave him that example. It's the same with the insert cases, even though if we say that they are not relevant, but they are. But if we say that they are not relevant, they are still morally repugnant cases that have been alive since 118 years, establishing a distinction between incorporated and unincorporated territories with no basis on the Constitution's text, and with the reasoning that it's purely considering the differences in race of these territories. So I took the opportunity to give him that example, and then I didn't receive any more questions from him about that. And my other main issue was the remedy, where I wanted to state clear that throughout the whole argument, we were, all the parties, all the advocates were talking about millions of dollars and the consequences of this case with respect to those millions of dollars and the bondholders, but nobody talked about the people. Nobody talked about the effects of the decisions of the Oversight Board to the people. And that was my opportunity to say we forgot about that, and what the Oversight Board of the United States are asking this court to do is to validate decisions of the court that, like I mentioned when I started talking, that are about the certification of a fiscal plan that is not subject to judicial review, with austerity measures imposed on the people. We're talking about agreements with bondholders that prioritize the payment of the bonds and not considering the people and the effect on the people and the economy, because at the end of the day, all of these actions by the board don't represent economic growth for Puerto Rico. Therefore, there's no way that Puerto Rico is going to be able to get out of this problem of this bankruptcy and get out of the oversight board, of the imposition of the oversight board. So that was about it for my 10 minutes at the Supreme Court. And I think I've talked too much, so I want to give the opportunity to Charlie.
Well, at least you had 10 minutes.
Yes. Yes, actually, the government of Puerto Rico asked time to present oral argument, and they were denied.
Well, a funny thing that the Puerto Rican government didn't even file a brief in this case at the Supreme Court level. It's total absence of the position of the local government. First, I would like to thank for the invitation, particularly Michael. He just wanted me to practice my English and to abandon the comfort of the warm weather of Puerto Rico. But here I am, so thanks Michael and the great people of Winston and Stone and take care of business. They're great people and I do appreciate what everything they're doing. And so I represent the municipality of San Juan in this matter. And it is important to notice why this case is important to the municipality of San Juan. Well, first, there are 250 million reasons for stopping the fiscal plan. The fiscal plan adopted by the board actually reduced the amount of money that the local government allocated to the municipalities in Puerto Rico. In the case of San Juan, it's close to $60 million. Of those, 350 million, close to 60 goes, $60 million goes to the municipality of San Juan. That's one. Second, there's a decision made by the board to certify the municipalities of Puerto Rico as covered entities under PROMESA. That means that the board decided to take over the financial decisions of the municipalities in Puerto Rico. That decision alone has an impact of several billion dollars. All those, if you add all those budgets from all those municipalities, it's several billion dollars. The weird thing is that that decision was made after the First Circuit concluded that the board was unconstitutional. So when the case reached the Supreme Court, the municipality of San Juan filed amicus brief stating one, that the municipality supported the plaintiff's claim that the members of the federal board were high-level federal officers subject to the provisions of the Appointment Clause. And we support that conclusion, even though the board and the U.S. government argued that the matter was resolved by the labels used by Congress, as Jessica mentioned. And those labels define the board as an entity within the territorial government. However, the board minimized the fact that the local government has no, I insist, no authority to appoint its members, or no control or to supervise the actions of the board. The very text of PROMESA is clear. Quote, neither the governor nor the legislature may exercise any control, supervision, oversight, or review over the oversight board or its activities. That is the text of PROMESA. So, based on that text, and using as a base the case of Lucia versus Securities Exchange Commission, we asked the court to determine if the members of the board were federal or local officers. We agreed there were federal officers, and the criteria were there. I'm not going to go into that. As a result of that conclusion, All decisions, I insist, all decisions made by the board are unconstitutional and invalid. Therefore, the remedy provided by the first court was insufficient to cure the constitutional deviation, and the de facto officer doctrine was misapplied by the First Circuit in order to provide an efficient remedy. If the Supreme Court were to accept the application of the de facto officer doctrine, there's no reason to validate decisions taken by the board after the court has determined that the board was unconstitutional. Remember, there's no precedent to prospective application of the de facto officer doctrine. That issue, as I mentioned, is particularly important to the Municipality of San Juan because there are several decisions taken by the board after the First Circuit concluded that the board was unconstitutional. That issue is actually been litigated in a separate case by the Municipality of San Juan against the board. As Mayor Cruz says, that's the mayor of San Juan, you either consent or confront the board, and in San Juan we had decided to confront the board. With respect to the insert cases, we do agree with the preface, with the UTIER position. It is amazing that 120, close to 100 something years ago, later, those cases are still in place. If we consider that those decisions were taken by the very same court that decided Plessy versus Ferguson, the same motivation, the same view, so there's no reason to insist in their application. But after reading that hearing and hearing the arguments, and that particular expression by the Chief Justice, seems obvious to me that the Supreme Court doesn't have any interest in going into that matter for the time being. And that is unfortunate, because people of Puerto Rico expect more from the Supreme Court of the United States. So, based on what I heard during the oral argument, I had to conclude that there is actually two ways to decide this case. On one hand, the court can conclude that based on the extension of the territorial clause, the Congress had the power to enact PROMESA, and just the fact that they defined the board as a local entity is enough to sustain that they're in fact a local entity, and therefore there's no need to go into the criteria of the federal officer if they're federal officers or not. And then, after that conclusion, they don't have to go they don't have to get into the discussion of whether the de facto officer applies or not. That's one way to look at things. Of course, it can be wrong, and hopefully I am. The court can conclude that it is obvious that the members of the board are federal officers and that their appointments were made in violation of the U.S. Constitution. As a result, they can conclude that all the decisions are invalid because the de facto officer doctrine does not validate unconstitutional actions. In that scenario, all elements of PROMESA that are not related to the existence of the board, such as the litigation stay or bankruptcy proceedings, will remain in place, and the local government will occupy the position and exercise the authority that is at present in the hands of the board until Congress provides another remedy. Hopefully that's the way that the Supreme Court will take. That's the path that the Supreme Court will take. But I don't feel that optimism any longer after hearing the expression of several of the members of the court during oral argument. For San Juan, this is a very important issue. and has to do directly to the provision of essential services to the people of Puerto Rico. All municipalities provide public services. Some of those services are essential, but all of them need funds, money to operate and to provide the services. In the case of San Juan, just the reduction of those amounts of money is enough to affect the lives of close to 360,000 people in Puerto Rico.
All right, so that you both mentioned, there's a lot there that I want to parse out a little bit. And one common theme is definitely around the insular cases. And listening, and the ACLU submitted an amicus brief specifically on this issue, and the cases were just exclusively about why the insular cases should be overturned. But to your point, Jessica, mentioning that that the government really relied, and other parties really relied on the insular cases and the district and appellate court level, and at least the presumptions of them, right, were present throughout their arguments and throughout their brief. And what I'm wondering is if there are other underlying assumptions that are also present that we're not specifically naming, but that are being, rested upon. And when I think about kind of the arguments of the government at oral argument and in their brief, and I juxtapose that to, for example, the uprising this summer, and think about, is there still a presumption that, to your point, the language of the insular cases really lifted up 118 years ago, that the island is wholly incompetent to self-govern? That there's a presumption of the inability to govern, that there's corruption down there, that these people are not, need or require or would benefit from a U.S. kind of imposed entity. If there's the presumption, so this language of belonging to, not a part of, foreign domestic citizen, the language that comes out of the insular cases, that we see similar language of presumptions in the position particularly of the government itself. I'm wondering if both of you think that that those presumptions are still very much present. And if so, how can we maybe be more explicit in naming them?
I think that's the impression. Actually, PROMESA was sold to the people as an act of Congress to save Puerto Rico from the financial crisis, and actually the people in Puerto Rico thought that this was something that we needed, that we needed Congress's intervention, the federal government's intervention, because we were not able to fix this by ourselves, and that we deserved this because of the corrupt government, and those were the ones that issued those bonds. But actually, I think, and there are arguments about this, that it's not the case. Yes, there is corruption in the government. Puerto Rico is not the only corrupt government in the world. But the situation in which, the financial situation in which Puerto Rico is because of the colonial status of Puerto Rico. And that's because of the United States. That's because of the insert cases that have prolonged the colonial status of Puerto Rico. And and I remembered studying for the oral argument, I was hearing the oral arguments of other cases just to practice, and I was hearing the oral argument of the Franklin case, which was about the Puerto Rico being able to being removed from the bankruptcy code and if Puerto Rico was able to enact its own bankruptcy legislation, which the Supreme Court said it's not. They can't do that. They can't file for bankruptcy, but they can also enact its own bankruptcy laws. So there, in that oral argument of that case, it was said to the court that the United States has micromanaged the Puerto Rico's debt since the beginning. It's a debt that it's triple exempt, that Congress has encouraged people, investors, to invest in those bonds, and it is something that is spread throughout the nation. So PROMESA is not something that was part of the argument of the discussion in this case. If it was a local concern or a national concern, it is a national concern. The decisions of the court have implications in a national sense. Not only they don't only affect the people or bondholders or local bondholders. So I do think that it is something that is bigger than the boundaries of the territory. It cannot be, the government of Puerto Rico cannot be fully blamed for the situation. The colonial status has had an enormous part on the problem, because Puerto Rico doesn't have the mechanisms to have economic growth, to be able to comply with all its obligations. So the impression that we are not able to self-govern, it's there from Congress, but it's not. That's not the whole problem in Puerto Rico, I believe.
Well, I have to agree with that argument. The thing is that, yes, there is a colonial situation in Puerto Rico, but in addition to that, to the fact that Puerto Rico doesn't have the tools to develop its economy, some decisions made by Congress have direct negative impact on the Puerto Rican economy. When PROMESA was enacted, I was a member of the House of Representatives in Puerto Rico. I was the majority leader back then. And I had the chance to discuss the bill with several members of Congress. And one of them said, well, how can you explain that Puerto Rico is ready to take control of its finances when you have $72 billion in debt? I said, well, that is correct, but I had to tell you that the per capita debt in the United States is actually higher than the debt that Puerto Ricans have. How can you explain that the federal government is able to govern itself under those circumstances? Of course, that meeting was kind of brief. And yes, there's a perception that Puerto Ricans are unable to govern ourselves. And that perception is still there. You just have to read some of the tweets of President Trump about this matter. But the problem is that all those decisions had direct consequences to the regular lives of the people who died. And yes, there's a significant debt. That is correct. And Puerto Ricans cannot avoid our responsibility for some of those decisions. But those circumstances were aggravated by the decisions made by Congress without our consent, and actually with evident insensibility towards the effect of those decisions on the local economy and our people.
Kind of picking up a little bit on that point, I think the only question that Justice Alito asked throughout the entire argument was directed to I think it's represented by Title former Solicitor General. And he said, just to be clear, right, your interest or economic interest, you're here arguing that this is an unconstitutional act because you want money. Your clients want more money.
He actually said we can't be cynical about this.
He said, I'm trying not to be pessimistic, but at the end of the day, there are real people behind these issues, and for you, your real people are your clients, and they don't want to negotiate, period, and they just want more money. Isn't that true? And he kind of forced this former Solicitor General to admit that. And you both obviously also have real people and real interest in wealth and that are behind this. To that end, what would be the impact on your clients, on the constituents you represent, if, for example, the de facto doctrine is allowed? Or to the contrary, if it's lifted? Like, what are the actual harms that are occurring here? Because I guess the second point of this question is, the challenge here, you both have spoken about the really the disastrous role of the board on the lives of Puerto Ricans, on Puerto Rican political entities, sub-entities, on organized labor, on citizens. But the challenge wasn't to the board as a legitimate act of congressional delegation of authority. It was to the composition of the board, right? It wasn't a challenge to whether the board in and of itself is legitimate. And that's because I presume it's been litigated and determined to be, but was there a reason for that? That's kind of the second, right? That's kind of the second half of the argument is, one, why wasn't there a direct challenge to the board? Given how kind of, the impact of the really tremendous and horrible impact that the decisions of the board have had on the lives of Puerto Ricans, but then also, what has that harm been? What is the harm to your clients?
Well, if we talk about specifically about the Puerto Rico Electric Power Authority, there's an agreement with the bondholders that the oversight board is negotiating right now that has been presented to the court for the court's approval, and that agreement is terrible, not only for the workers and for the instrumentality itself, but also for the entire island. We are talking about PREPA is the only entity, the only electricity provider in the island, and the agreement proposes to establish a transition charge, which will imply the consequences of that is that the electric bill will be higher, and we are, for example, it could get up to $100 higher from what we have now. The problem is that transition charge is the charge that is meant to be used to pay for the debt. A debt that the oversight board has said in other proceedings in PROMESA that is worth zero. But now, with the agreement, they are proposing to issue more debt so that it's a new one that is secured by the payment from the customers of PREPA of this transition charge that will increase the level of poverty in the island, that will increase the operational expenses of the businesses and of the government as well, because the government obviously consumes electricity from PREPA. And it even proposes a charge for the people that are connected to PREPA but have some sort of solar system. So we are talking about an agreement that is not feasible, it's not viable, and that has been done because the First Circuit allowed the board to continue operating. It's before the court, and it's to be discussed before Judge Zoey in January, because the First Circuit allowed the board to continue operating. The bondholders agreement provides for, as I mentioned before, for the payment of the bonds first ahead of the current expenses of PREPA, which means that all the money that PREPA collects from that transition charge has to go first to the bondholders, and then if there's something left, it can be used for the operations of PREPA. As you know, because of Hurricane Maria and much before that, the electric grid and all the infrastructure of the electric infrastructure in Puerto Rico is very, very in bad conditions, and after the hurricane it's worse. But PREPA has not, with this agreement, PREPA has not the ability to have income to invest in itself into its infrastructure. So it threatens the sustainability of PREPA. It provides for the payment of the bondholders ahead of salaries, ahead of contributions to the pension system. So that's something that if the actions of the board would be invalidated, that would be something that would be invalidated. Another agreement is the COFINA agreement, which was approved by the court in 2 days. I manage personal bankruptcy cases, and it has taken me months to confirm a Chapter 13 plan. And the plan of adjustments of COFINA, which was one of the Title III proceedings, was confirmed in 2 days with an agreement with the bondholders that provides that the bonds will be paid, new issued bonds would be paid by the the sales tax that people pay. But none of this is considering that the people are leaving the island. It could be a dumb question to ask where most of the Puerto Ricans live. It's not Puerto Rico. There are 5 million Puerto Ricans in the United States, 3 million in Puerto Rico, and the numbers keep keep decreasing because the people are living there. It's not, the people cannot sustain the cuts in their pensions, the cuts in their work, in their salaries, in their benefits, and also the increase in the rates of electricity, the increase in the other in other aspects of their life that are essential. So when we talk about things that could be invalidated, there's also the avoidance actions filed by the board. The board filed more than 250 avoidance actions through the bankruptcy proceedings to question the legality of the services provided by contractors to the government within the 4 years before the filing of the Title III proceedings. We are talking about complaints of more than $2 million each. And the lowest one is $2 million. We see complaints of 90 millions to local businesses, most of them. There are some international companies, but most of them are local businesses that have been sued by the oversight board, questioning the services that they provided to the government 4 years before. That could lead those businesses into bankruptcy themselves. So, and the closing of the schools, the projections to close the campuses of the University of Puerto Rico, the pension cuts, that's something that is being discussed these days now, and the governor is going ahead with it. It's a 8.5 pension cut, but it could be more. That leaves it doesn't touch the pensions that are $1,200 or less. But when we look at that, it's basically the minimum salary of $725 per, which we have been discussing in this past weeks, that it's not enough to live in Puerto Rico with that salary. And we have to consider the pension, that most of the pensioners in Puerto Rico, because of the situation that we're living in, they are living with their daughters or with their sons that are not working, or that they are contributing to the expenses of their grandchildren. So and we expect those people that gave their lives to working with the government to now accept a cut in their pension, and also continue to pay the high expense cost of living in Puerto Rico. So that's the things that the board has done. I cannot say that the board has made any progress in the 3 years that they have been imposed in Puerto Rico. I haven't seen anything that the board has done that could be said to be good for the people, only the bondholders. And I haven't mentioned that all of this is going on while the debt has not been audited. There has not been an audit of that debt. It's like, yes, the bondholders are saying you owe me this, and they are saying, okay, let's pay you this, without requesting, okay, let's see the legality of that debt. Let's see if it's something that has to be paid, that you have a right to collect or not. It has not been audited, and the board and even the government have refused to audit the debt, obviously because of the consequences for the government officials and that in that aspect. So that's what we're talking about.
Well, in addition to those, to the impact of the individuals in Puerto Rico, you have communitary impact. In the case of the municipalities, the decisions of the board are affecting essential services. Right now in Puerto Rico, we don't have money to pay the police. We don't have resources to pay autopsies. We have problems paying our health system. So, in the case of the municipality of San Juan, there are 3 basic essential services: education, security or safety, public safety, and health. All of these three areas are essential to the operation of the government. That is the minimum that a government can do. But of course, if those decisions of the board stand, it's just a matter of time before a municipality, not only San Juan, other municipalities with less resources will have to cut even those essential services. And we are not that far from that point. So it is important to realize that in addition to the financial aspect of this decision, there's another level. The impact of the existence of the board on the democratic institutions in Puerto Rico. You have a system based on the fact that you vote, you elect somebody to take decisions, and if you don't like those decisions, you're going to have a choice later on the road to get rid of the person. That's not happening in Puerto Rico. We didn't vote for the board or for the federal government to enact a board upon us. So it should be stressed that the problem in Puerto Rico is not just financial. Of course, that is a significant concern. And municipalities, yes, they need money like the bondholders, but for different reasons. We need money to pay for those essential services, not to get richer, but to pay for those services. So, but in addition to that, you have direct impact on the democratic institutions in Puerto Rico. You have a mayor, you're going to have a mayor that doesn't have any power to do anything, to solve any problem. It's just a matter of time. You have a governor right now in Puerto Rico, but in addition to be a governor of the colony of the United States, in addition to that particular limitations, you have a governor that doesn't have the powers to do anything without asking the board if they agree or not. And that's another level of the crisis, the democratic institutions.
To that point, which is significant, were there other municipalities that signed on to this one?
No, yes, sir.
I'm wondering.
They don't have the funds to pay for their legal defense. You will be surprised. The municipalities in Puerto Rico are so limited in their space, in their scope of operation, that they just cannot fight. They don't have the resources to fight for those resources. So that's why in most of these cases, only San Juan, since it's the largest municipality in Puerto Rico, has the conditions, the sources, and the leadership with Mayor Carmen Cruz to do this.
Is there any concern amongst the municipalities, or is there any concern that as there's been over $40 billion that's been appropriated in disaster relief funds. For Puerto Rico, only $1.5 billion of which has been released so far. And while there's been kind of explicit directives given that those funds couldn't fall within the purview of the board, for example, the board's to the extent that the board is attempting to bring in all of the municipalities under its reach, is there any concern that the federal funds, known as the Community Development Block Grant funds, that are intended to go directly to municipalities for infrastructure type projects, is something that those could be also brought within the board's purview?
Yes, we are concerned about that. But the thing is that right now in Congress, Congressman Grijalva is actually considering an amendment to PROMESA to guarantee that those funds actually get to the municipalities. So you don't have to go through the board, but that goes back to the issue of trust. The federal government doesn't trust the government of Puerto Rico. And then they prefer to allocate those funds through a procedure under the umbrella of the board.
I do want to open it up for questions in just a minute. But just lastly, you mentioned
legislation. This is a congressionally created entity. Now we see, excuse me, that Congress is trying to maybe step back a little bit, at least in thinking through amendments to PROMESA, not overruling PROMESA, not eliminating the board. Do you see, trying to define, for example, essential public services, whether you mentioned those three, but perhaps the definition could be, included more, though at that point, it's arguable that it would be somewhat fluid if the fiscal plan and adjustment has already been approved. That wouldn't likely affect any, I wouldn't redefine that, for example. Given, depending on what we get out of the Supreme Court in the next couple of months, do you think that there should be any particular ask towards Congress as they are looking at PROMESA again, recognizing the devastation that it's had on the island, the deep discontent that it's sowed on the island amongst Puerto Ricans? Should we be thinking of also a legislative strategy here in addition to a judicial one?
Well, most of these issues are political in nature. So Congress has to intervene. And Congressman Grijalva is considering several amendments to PROMESA. And I feel quite optimistic that at least in the House of Representatives, we're having a sympathetic ear. It's too early to know whether we're going to have a chance in the Senate or if the President will be willing to sign this. But at least we are making some ground here in the House. And the process is still in the very early stage.
Well, my position is that there should not be an oversight board, and there should not be a PROMESA, and that the problem is the colonial status of Puerto Rico. But still, if we do have to look at the amendments, I think that they try to somehow provide a remedy for what Congress has, for what Congress enacted initially, because now Congress sees that they don't have any power over the board. The only one that can remove the oversight board members is the president. So now Congress is not, some members of Congress are not agreeing with the decisions of the board, so they see the need for these amendments. For example, one of the amendments is to have an audit of the debt. Also for the board to establish some criteria to define what it is and what's an essential service, because PROMESA requires that there should be a definition of the essential services, because you have to protect those services and ensure that the Commonwealth is able to provide those. But the board has refused to define the essential services. So the amendments go to define the University of Puerto Rico as an essential service and give it more funds. Also,
ethics, some provisions regarding the ethical considerations.
Yes, because we now know that the oversight board members have conflict of interests, but since they didn't go through the advising consent of the Senate, it's something that we knew afterwards. And now there's no one that can remove them aside from the president. So the amendments, I think that come in good faith, but we first need to see if they would get approved, because when I was hearing the sessions in Congress, some of them were saying that it was not like that they didn't have enough time to consider it or something like that. So let's see what happens.
I would like to open it up for questions at this point.
Hi, good morning, and thank you all for being here. My name is Juan and I'm on the Puerto Rican task force with the New York City Bar Association. And thank you, Natasha, for this. I have a very specific question, and that is with respect to the auditing of the debt. I've always wondered why that hadn't happened sooner, an issue that was sort of raised even from the very beginning. But what does an audit in your mind sort of look like? Does it also, because in my mind, when I think of an audit of that kind, where you have investments that are being questioned, and whether those investments were, were proper and all that, I think about not just that you gave money, you deserve it back, right? But also that there are other criteria. what does an audit for Puerto Rico and the debt, the bonds, the debt look like in your mind?
It goes in that line, but it's also just where how much money how much money are we talking about in interest and principal? For what was the money used? Because that's also an important part. And in Puerto Rico, we have a constitutional limit to the issuance of those bonds, so it's to make sure that that was respected, or if that was respected or not, to see what is of those bonds which are secured, which are not. So it's a forensic audit, basically, to not only see if those bondholders have the right to get paid, but also to get people responsible for the misuse of those funds if they were misused, and I know that they were. And that's when you say that you don't understand why they haven't done this. I don't understand it either, because when you go to a restaurant and you get the check, the first thing that you do, or that you should do, is to see if they are charging you for what you hate, and that's basic. But here, for some reason, and I believe that it has to do a lot with the public officials that were involved in the issuance of those bonds and the responsibility that they would have. I think that has a lot to do with it. But it's a forensic audit. It's to look at everything that was issued, for what was it used, and how much, and what's the interest, and what's the principal, and it's basically to cover all the basics.
And what legality would be used? I mean, what sort of legal structure would be used to sort of get an audit going? I mean, I'm thinking along the lines of, like I said, you're an investor, you invest, so long as you've met, the person who's taken your money has done certain things, like, for example, they've not placed you in sort of, extravagant investments, right? When you're a 80-year-old trying to save for your, the next, few years that you have left. So do you understand what I'm saying? Like, what legality, what structure, legal structure would be used? Would it be, like, for example, the SEC rules, or similar, or some other criteria, fairness?
Back in 2016, in the local House of Representatives, we approved legislation to provide for the audit of the debt.
Well, there was a commission created.
There was a commission.
We created the commission to audit the debt, and we were kind of happy with that. Suddenly, there was a change in the government, and the new governor decided to get rid of the law. So they decided that the audit was not necessary, and disbanded the commission. Of course, that's pathetic. This is like not taking a look at the check in the restaurant because you don't want to know how much you ate. So this is the issues that we're facing, of course. There's another element. Like a year ago, they found out that close to $3 billion were actually borrowed against the debt ceiling of our Constitution. That was actually a legal conclusion made by the board. And they notified everybody. Listen, this is a constitutional debt. We shouldn't pay for this. And like a few months later, they include those very same funds in the debt agreement. And nothing happened. And that was a unilateral decision of the board that we are not able to challenge it for. So, if we made the wrongdoings in the issuance of those debts, at least we must have the chance to take a look at those transactions. But it's amazing me, like it's surprising to you also, how the board insists, how all those, even the local government of Puerto Rico right now, insists that the audit is not necessary when at least you have one instance when the board says that debt was unconstitutional, $3 million. At least just one example. Just imagine how much we can find in $72 billion. And the Puerto Ricans deserve that if they're paying the price of those decisions.
I'll just add one quick note onto the debt point. In addition to it was a bipartisan commission that was formed that was disbanded by the former governor of State. But the board has conducted their version of an audit, and just to be clear, that audit has not been accepted by the majority of Puerto Ricans. That's why there's an organization, the which is a large citizen-scale coalition that's really demanding a forensic audit of the debt that includes a much deeper delve into the legality beyond just the constitutionality, right? Legality also under equitable principles, not just legal principles. So the $9 billion or so that was declared, I think, unconstitutional by the board isn't where the inquiry stops, right? Because the request is much broader than that. There's been over 100,000 Puerto Ricans that have signed petitions demanding a full audit of the debt. And because now there's no local representation, but there's no commission that exists. Title III proceedings, Judge Zoey, is allowing the board to make these determinations, and that non-transparent kind of closed proceeding is what is really being rejected, as I understand from Puerto Ricans, and saying, no, we actually demand a full accounting of this debt.
Hi, good morning. As you know, we've been present at the hearings locally here as well as in Puerto Rico, and we've witnessed the unconstitutional behavior from the PROMESA board with regards to this debt, and that's what's compelling us here from the diaspora to attend more and more of these hearings and formalize coalitions here stateside. My question is, with regards to the audit, since most of the transactions were here in New York State, the Attorney General would have the authority, Tish James, correct? Would she have the authority to request and ignite an audit? That's one. With regards to the depopulation rate, some of the PREPA rates being negotiated will supersede what New York City residents pay here. So that doesn't match the median income to the average rate for electricity. And there's also talk of increase in property taxes in Puerto Rico. So if you have these accelerated increases and accelerated depopulation, who's going to pay the debt if there's no one there to pay it?
The people that stay.
Then you have the Medicaid. Then you have the Medicaid fiscal cliff that just passed.
Actually, it's worse than that, because people that are not able to move to the States are older.
Correct.
So you're putting the weight of those decisions on the shoulders of our elderly.
Right.
And that's adding a catastrophe to a problem that is already
Existing.
critical.
Yeah. And then you have the Medicaid fiscal cliff that just expired at September 30th. I know it doesn't have to do with PROMESA, but from a congressional standpoint, it does.
It does,
And no
because
one
it's
has sponsored.
service.
Right. So you have 900,000 people going to lose their Medicaid.
Right.
And then you have the increase in property taxes, the increase in PREPA, and then the COFINA payment. So, and if
our local taxes.
correct, right. And if the composition of the board was deemed unconstitutional, why are these hearings still taking place?
Well, because they were allowed to continue operating.
Right.
The court of the First Circuit allowed them to continue operating. With respect to the decreasing population, experts say with respect to PREPA that more than 50% of the people will not be able to comply with the payment of the electricity bill as it will go up.
Gotcha.
And you are expecting the lower class and the middle class to get that to get the burden of paying for the increase in the electricity bill, because those that have the economic means, they would go to solar energy with batteries, which is very expensive, but they could do it, they could afford it, or they would just go and come here to live at the States. So the people that don't have the means to produce their own energy or to leave the island are the ones that are going to be paying, and that's the lower class.
And the AG?
Also, you have another problem. The thing is, the problem is not also that it's not only that people are moving to Florida or anywhere. The thing is that the people that remain in Puerto Rico are refusing to have additional kids because the prospect of the future are so terrible that they say, well, forget it, we're not going to have kids. Unless it's actually happening in Puerto Rico. The level of newborns in Puerto Rico has been on the slow, decreasing slope for like 10 years, something like that.
Or they are struggling with their own expenses. How can they manage more expenses that come from a baby? So it's not possible.
Just a quick note on the New York AG. I'm not sure that the AG would have the authority to audit or to issue demand audit, but certainly has the ability to investigate and prosecute
Those practices.
Yes, right. Unethical, possibly illegal practices that occurred within New York, and we know that this AG and certainly her predecessors have had a strong record within themselves.
Yeah, one couple of things. One is the observation of something you mentioned of changing unsecured debt to secured debt, and I think it's almost passing everyone over their heads because that makes such a huge difference in the standing of that debt, especially when Elizabeth Warren submitted a bill to try to basically exempt or make unsecured debt, basically forgive unsecured debt. So that makes a huge difference even for that one bill, because then you just created a loophole on the law for show. That's one thing. The other thing is, as far as doing a forensic debt, you really have to go back many years and see how funds have been used, like Jessica said. One of the examples are just recently in Bloomberg, they were talking about Goldman Sachs wants to sell their stake of Los Peajes de Puerto Rico. Think about that. Los Peajes de Puerto Rico, during his first negotiation of that, was with Fortuño, the tolls. That's basically the toll systems in Puerto Rico. He negotiated, they negotiated a really nice deal for the tolls of Puerto Rico. Afterwards, when Puerto Rico wasn't able to make some of its bond payments just right before it went into bankruptcy, Goldman Sachs came up with a better deal. They allowed them to not pay, I believe it was about $100 million, in exchange for increasing their stake, their profit on the tolls, and increasing their time of holding the tolls. It was an exponential increase. I don't have the exact numbers right now, but the governor that was there at the time, he ended up having a position with one of Goldman Sachs' partner companies in Spain after that. So, huh?
The governor that made the decision is
Luis Fortuño.
Yeah,
Luis Fortuño.
The board of the very same company that is benefiting from this.
Right. So you start looking at how this debt keeps spiraling. You borrow debt. The Refund American Project made an investigation. They found $2.5 billion that was later increased to $18 billion. It was a capital appreciation bond. And several months ago, during the 3-year anniversary of PROMESA, I asked Natalie Carrasco right outside the hearing room how much of the debt is principal versus interest and fees, and she couldn't even answer that.
No one. And you have to consider that these agreements are 40 years. COFINA is 40 years, and the agreement of PREPA is 47 years. Yeah. With projections that are unrealistic, that are not considering the decreasing population as it is rapidly going on, and it's not considering another hurricane. That with respect to PREPA, that is very, very important, and it's not considering that. So we are talking of agreements that most of the people in the legislature that would have to approve those agreements are not going to be alive when the agreement comes to an end.
In the midst of this, they're considering selling PREPA.
Yes, it's all true privatized, yes, it's all true privatized. But the problem is that PREPA has not invested in its own infrastructure for so many years. You are asking investors to come in and buy junk.
Right.
So they are also having a problem with finding investors for PREPA. That's why they want to accelerate the approval of the agreement, because they want to say to the investors, we have this covered, this will be paid, even though it's, like I mentioned, with unrealistic projections, but this will be paid, so you are safe to invest in this. But what's going to happen? Those investors will have to continue investing in PREPA, in its infrastructure, and what's the meaning of that? More increase in the rates for the people, because that's how you're going to be able to pay.
So they're puffing it up for the sale.
And the cut for PREPA, it's 22%. The haircut of the debt, it's 22%. That's. I have had cases, a collection of money with a credit card, which is not the original credit card, and I've had a haircut of 60%. But with PREPA, it's 22%.
Thank you. I just want to add my thanks to this panel, so informative. I'm Camille Massey from the Sorensen Center at CUNY School of Law. And my question goes back to pulling back the lens a little bit and the overall strategy. In addition to the legal strategy and potentially a legislative strategy, Natasha, that you mentioned, I'm curious about the stories of those who have been affected, the damages by the workers and how the Puerto Rican people have been affected by this, as well as the racist doctrine, and whether or not there are ways of telling that story more publicly that haven't been done that can be influential, and also whether people outside of the U.S., I'm thinking of some voices of prominent lawyers who've been looking at this situation, if you think that would be useful in tapping beyond.
Well, I'm going to give you with respect to the impact on the people, my personal experience. For example, my brother, he has a doctorate degree in chemical engineering from the University of Puerto Rico, but he had to leave the island because he didn't find any jobs because of the financial situation. Now, my father, he's an engineer of PREPA, so he's going to have his pension cut, and now he's struggling to comply with all of his financial his financial obligations, because you rely on that income, and now it's going to be cut. My mother worked at a school that was closed, so now she's unemployed. And I have a brother, a younger brother, who's studying at the University of Puerto Rico, that his campus is one of the ones that it's going to survive. It's 11 campuses, and they are planning to close and leave only 3. So we have, so in my family, and I obviously have to pay more for electricity and all of that. So everybody is affected, and some of them in a worst way, right? But still, everybody is affected. You have, in the judicial system, for example, we have courtrooms that have closed. So people, to get those services, people have to travel more. That's the same with the schools. So, and Charlie mentioned that there's no money from the municipalities to pay for policemen, for healthcare issues. So it's affecting everybody. With respect to the insert cases, a few days after the oral argument, Congressman Grijalva announced a resolution rejecting the racist language of the insert cases, and that's something to keep the discussion going on. I do have to be optimistic about the results of the case, of the Appointments Clause case, because if I wasn't that optimistic, we wouldn't be at the point that we're at. We were the underdogs. We are the union. We are fighting against the oversight board and all the powers of the U.S. government, and still we made it to the Supreme Court, and our petition was granted, and we were able to argue. Those are things that are not easily obtained. So I do have to be optimistic, and if the Supreme Court doesn't address the insert cases, Well, it's not a matter of giving a knockout, it's a matter of stay making punches through the 12 rounds. It's, we had the opportunity now, we took it, and we're gonna have it again, and we're gonna keep on questioning that. And I believe that the participation of the people outside of Puerto Rico, the diaspora, is very important because it is a big community. They are still very attached to. They have a family in Puerto Rico that most of them have family in Puerto Rico that are struggling with these decisions and all the actions of the oversight board. So movements here matter as much as those that are at the island, in the island. I wish that every time that there was a hearing, there would be people here and there protesting about this, because at the end of the day, that has an impact on the judges, and also it helps with the press to spread out what's going on. So I do think that the work that the organizations do outside of Puerto Rico is very valuable.
Maybe like last word. I'll just add lastly, because I'm mindful of time, that to your comment, Camille, which is really well received. And I think the average salary in Puerto Rico is somewhere around $18,000 or so a year, or at least it was several years ago.
20,000.
Yeah, 20,000. And there's a $72 billion debt. And you think about who's going to pay that, it's going to be somebody whose salary is $20,000 a year, increasingly, right? And we see that burden going into the form of taxes, but it's the people who have absolutely no ability to pay. So every single person that is affected, and their families, like the nation of Puerto Rico, 9 million people that are affected. I also think it would be extremely useful to think of the larger legal community and how we can involve them and pay attention to this. I mean, one thing that I thought was interesting when you were arguing a month ago, and speaking specifically to Chief Justice Roberts around the Silver cases, that he said, "I agree with you." Right? It's an abominable doctrine. And yet we don't see any indication so far that they're going to overturn it. Sure. And so to the extent that there are, the government and creditors are relying on that doctrine, well, the court is relying on it too, right? At least implicitly. So it's really incumbent upon us in the legal community to think about, well, if this doctrine continues to exist, the presumptions that it brings, the explicitly racist, imperialistic presumptions that it brings, and that doctrines that the court continues to, at least in the last 3 years, these 3 cases, potentially, presuming this one will also be rested upon that, then what is our role in speaking out about that? I'm mindful of time. I want to make sure that we don't want to over and let everybody leave in the middle while we're still talking. So if you still have a question you didn't get a chance to answer, please come up and speak to our guests. I want to thank you all for coming. And I also want to appreciate that Facebook Live feed. We'll figure out a way to be able to distribute that to folks who weren't able to make it. Thank you all, and thank you to our guests.
Thank you for coming.